Okay, so do you have any question before we move to board of investigate this we completed another part will be a consolation. Any question so far?
So far, no questions, madam.
So can we continue with the second part or not?
Yes.
Okay. Just for a while, okay. Is- Okay, students, consolation. Okay, so the second part will be a consolation. Okay, consolation, like we're going to consult with the other party. Okay, it is not negotiation. In Malay, it will be like pendamaian. You want to settle the matter. Okay, but this will be under part 5 of the Industrial Relation Act. Okay. So, Section 18 says that a trade dispute may be reported to the Director General by an employer or employees union. Okay, so an employee himself cannot go for conciliation. Okay, it must be by an employer or the employees union. Okay, so the director shall consider the dispute. Okay, that means he will study what is the dispute about and take necessary steps for promoting a settlement. Okay, that means it will not be like what do you call the matter will not be brought straight away to the court, but it will be like two parties, okay, the employer and the director will be try to settle the matter. Okay, that is for promoting settlement. That means they will try to settle the matter so that the matter will not go further to the court. Okay, so this is where the employer and the employees union. Okay, the second part is where under subsection 3, a trade union which was not reported. Okay, you can see one is reported, one is not reported. Okay, a trade dispute which has not been reported to the Director General, and it seems that it is not likely to be settled by the parties. Okay, the director may also, in the public interest, take steps as necessary to promote settlement. Okay, so for conciliation, it can be where the parties, like employer and the employees union, refer the matter to the Director General, or the Director General came to know about the trade dispute, okay, which has not been reported. Maybe he came to know by third party or maybe by the media. Okay, he can also intervene to settle the matter for the public interest. Okay, so he must take steps as necessary to promote a settlement. Okay, so conciliation part 5, can the students understand? Can you all understand?
Yes, I can understand.
Okay, About the others, okay, Arisha says can understand, good. Okay, so this is where um, um, okay, no, thank you. Trade dispute been reported, okay, to the Director General by the employer or the employees trade union. Okay. So the director shall notify the minister accordingly if he is satisfied there is no likelihood of settlement. Okay, so of course, when the matter has been referred to the Director General, he will try to settle first. Okay, if he cannot settle, then only he refer the matter to the Director General. Okay, so sorry, he will refer the matter to the minister from the Director General. Okay, Director General shall notify the minister. Okay, if he's satisfied that there is no likelihood of being settled. Okay, then section 19 says that the party shall furnish all the necessary information to the Director General. Okay, together with any appropriate statement setting out the points. Okay, then the Director General may direct any other person indirectly connected to the parties to attend. Okay, so of course, for the investigation purpose, you want to make settlement, you must get all the information. So the parties, or the employer or the trade union, must finish all the necessary information to the Director General to promote the settlement. Okay. Since if the Director General cannot settle, of course, he will refer the matter to the minister, and the minister here make conciliation in the trade dispute. So in the conciliation proceeding, the parties may be represented by themselves or be represented by any other person, such as trade union, but they cannot be represented by the advocate and solicitor. Okay, that means for the trade union of the employee, okay, they can be represented by the trade union itself. Okay, but no lawyers are allowed to represent the parties. Okay, so conciliation process is if you compare with investigation, so investigation will be like for more serious problem. Conciliation is where it is less serious problem, but it's still connected to the trade dispute between the employer and the employee. Okay, and that's how section 18 and 19 plays the role for conciliation. So any question on conciliation?
No, madam.
Okay, Sarita, okay. No, thank you. Okay, so for the third type is where you already studied is arbitration. So even though the word is arbitration here, and we know the agency for arbitration in the industrial relation is the industrial court, and you have learned about industrial court, I think in the second lecture, okay, second week lecture, okay. So the industrial court also plays an important role to settle disputes, any trade dispute like dispute on collective agreement, on picket, on strike, on lockout, okay, any dispute, okay, regarding any dispute between employer and employee, and also regarding terms and condition like for the collective bargaining and also collective agreement. Okay, I think you can still remember that industrial court have a president and a few chairmen for each of the industrial court in few states. I think about 4 states in Malaysia, and they have 2 panels. One panel representing employer and the other panel representing employee. Okay, so I'm not going over again on the industrial court because you already studied in the early lectures. Okay, so any question that you want to ask about trade dispute?
Madam,
Yes.
I can understand the conciliation and arbitration,
Mm-hmm.
but what's the purpose of investigation then? Because
Mhm.
I see that there's no solution in the investigation.
Investigation, wait, let me see. Okay. So in investigation is when um here you can see investigation, even though it says that uh, the parties okay facing trade dispute must refer the matter to the either a committee of investigation or board of inquiry, okay. But this is where for a serious matter, if you can compare with the conciliation is between the employer and the trade union, okay. And I think you will also say that for the investigation, it will be also the employer and the trade union, okay. Of course we will have the same party, okay. But here investigation is where the board of inquiry have to investigate, the committee of investigation also have to investigate. They have to investigate, and then they have to call the parties to give evidence, okay. And also to get, like in the board of inquiry, they have to get the permission of the chairman first before they can appear before the board of inquiry, okay. So this will be very serious trade dispute, okay. That's what I can say lah. Okay, for investigation it will be very serious trade dispute, and for the conciliation it will be like very general, or maybe like common trade dispute between the employer and the employee, okay. Because the act actually have not like drawn line, what matters actually can be referred to the board of inquiry, and also what matters can be brought to the what do you call conciliation, okay. Because under the investigation, you must also make a report, and the report must be laid down in the Dewan Rakyat, okay, Lecce?
So, madam, so we can say that the information that gathered in this investigation will be used in the industrial court.
In the industrial court,
Because industrial court is a last resort, right? If things cannot be
yes,
settled.
yes, but normally if you want to appear in the industrial court, okay, you must again produce the evidence, you must bring the witness, okay. um if it is like information given, okay, normally if you want to appear before the court, the person who give the information must appear and bring the evidence again. You cannot just like submit the evidence or the report will be useful lah. But if you want to give information, you must appear in person to give the information again, because it's the rule to give evidence. The person must appear. The person, like, in case like you want to investigate, let's say a simple matter in a road accident, the doctor who give the report on the medical injury, okay, he must appear in before the court to give to the judge that he is the person who wrote the report on the injury, okay. Some other person cannot appear to give, okay.
Okay, madam, thank you.
Yeah. So any other question, students? So far, no question. Okay. So so from the trade dispute, okay, we have trade dispute and the resolution. So when there's a trade dispute, when there's any dispute between the employer and employee regarding terms and condition, between something to do with the relationship, or maybe a social security, or maybe for their welfare. Okay, so when there's a dispute on this matter, okay, there will be most probably strike, or maybe there can be a picket or lockout. Okay, and the matter between two parties, employer and the employee and the trade union, must be settled. Okay, that's why we have the conciliation process here. Okay, so far I'm not sure how many cases okay, have been referred for section 34. Okay, I've not for section 18, yes, there's a few cases, okay, but for the section like 34, I'm not sure whether there's any case that you can refer for the investigation. Okay, so i- if you have any question, you can ask me regarding this session. And also there's one article that I wrote on dispute resolution also, but it's in Bahasa Malaysia, that you can also read on that case. Okay, so anything that you want to ask me, or maybe I can stop here.
I don't have questions anymore.
Okay, how about the others? Can we end the class here? Okay, okay.